morning, everyone, and welcome. Thank you for joining, and apologies for keeping you waiting. This is an instalment of the Radcliffe Chambers Junior Programme. The purpose of this programme is to have junior members of our chambers give talks to junior members of firms about our practice areas, and in particular, talks about the basics. Of course, if you don't call yourself the most junior member of your firm, there is no shame in attending a seminar like this one. We all know the importance of getting a regular refresher of the basics and having a good grounding in the basics. I'll talk today within the topic of civil fraud litigation about gagging orders and how they're used in civil fraud litigation. They're an important tool for a civil fraud litigator to have in mind as part of the toolbox, and I'll talk about their typical use in the civil fraud context. Their typical use, of course, is as a form of order ancillary to any other primary interim relief you might be seeking in order to protect the secrecy of the attempts you're making to get that primary interim relief. And there is a need to differentiate the use in the civil fraud litigation context, a need to differentiate between the use in that context on the one hand, and then on the other hand, the use of interim non-disclosure orders, or gagging orders as they're called more colloquially, in the entirely different realm of media cases. And there's sometimes some awkwardness and difficulty because there is an entirely different realm in which these orders are often sought, and the law from that realm and the practice sometimes leaks over. I'm going to use some slides today, and those will be circulated after the webinar. So feel free to rely on that assurance while you're taking your notes. Time permitting, I will speak about three topics. First, the basics. Second, the legal test. And third, procedural matters. And as for the practical points, which are always important to bear in mind, I will intersperse them throughout what I talk about. So let's begin with the basics. So what is a gagging order, or an interim non-disclosure order, or as I will call it, an INDO? It's a form of interim injunction. Its effect is to prohibit the respondent to the injunction from disclosing information to other persons. You can expect even a broadly drafted INDO to permit certain exclusions, such as those permitting the respondent to disclose the matters which are protected, at least for the purposes of accessing legal advice. I've spoken a little already about the typical use of INDOs in civil fraud litigation. Usually an INDO application is made at the same time as and ancillary to some application for the principal interim remedy you're seeking. For example, a Norwich Pharmacal order. So the INDO application is made at the same time and in reality forms part of the Norwich Pharmacal application. That is the principal interim remedy you're seeking. The interim remedy will normally be sought against an innocent third party or co-wrongdoer. I say co-wrongdoer because there may be one wrongdoer whom you've identified, but you may need to get relief against them to identify another, or indeed to seek information about the wrongdoing, gain evidence about it, as well as obtaining the identity of the wrongdoer, or getting information to help preserve assets. It will be desirable to secure an INDO for the real key purpose of preventing disclosure by the respondent of certain matters which would prejudice your attempts to obtain the remedy for the wrongdoing. In other words, they may prejudice your attempts to get the principal interim remedy you're seeking now, for example, the Norwich Pharmacal order. But the real danger is likely to be that your attempts to use what you get out of the Norwich Pharmacal order, your attempts to claim and recover against the wrongdoer ultimately, your ultimate step, the risk is that that ultimate step is prejudiced. And the information that you want not to be disclosed by the respondent to your principal interim relief application is usually the following. One, the fact of proceedings. Two, and by proceedings I mean the application for the principal interim relief and the INDO. Two, the contents of the order. And the contents, thirdly, the contents of the application documents. And the third and fourth of those sub-bullet points are straying a little bit from the main elements you tend to want to prevent, the main of the first two. But going further, it's often also desirable to have the contents of the application documents prevented from disclosure, because of course those application documents will very likely contain the body of information you rely upon in order to all the body of information that you've gathered so far, which might help you pursue the ultimate wrongdoer, and in other words, to help you take your ultimate step against the wrongdoer after you've obtained your principal interim relief. And as well as that body of information, it will of course possibly include the analysis that you've already conducted of that information, the inferences you've drawn, and that sort of information would reveal to a wrongdoer how far you've come in your investigations, how close you are after the tail. And finally, the fourth of those elements, it's likely that you would also want to prevent disclosure of the possibility of proceedings being brought against the wrongdoers. So in other words, the ultimate proceedings after you have your interim relief sorted out. So this is the form of a typical Indo in civil fraud litigation. And this is in other words, normally the wording of the central paragraph, or something similar to the central wording of the central paragraph. I'll read it out briefly for assistance. Except for the purpose of obtaining legal advice, the respondent must not directly or indirectly inform anyone of these proceedings or of the contents of this order, or warn anyone that proceedings have been or may be brought against the respondent by the applicant until a certain point, being the time of the return date, or further order. So you'll see in that text, the first two sub-bullet points, the fact of proceedings and the contents of the order. That's what the typical central model wording is going to, but there may be reasons for you to expand this wording. And I've taken this wording from the model search and imaging order, which has a built-in Indo at paragraph 26 in these terms. There is a need, as I've mentioned, for us to compare the position with how Indos are sought in the media cases. There's a conceptual difference between our civil fraud cases on the one hand and media cases on the other hand, and it's important for us to understand that conceptual difference if we are to understand how to obtain our Indo in this context. And I've mentioned these two categories of case. There may be cases which fall in between these two categories. I'll allude to them later, time permitting, but we don't need to be concerned with them for now. So first, on the one hand, we have media cases. So the media cases are typically cases where the claimant ultimately seeks to claim at trial for a breach of privacy, a breach of confidentiality, threatened contempt of court, threatened libel, malicious falsehood, or harassment, or something akin to that. And then on the other hand, we have the civil fraud cases. I've just set out the use case in the civil fraud cases, and we're all aware of the sorts of causes of action we might pursue at trial in a civil fraud matter. So on the one hand, we have media cases and a few characteristics of them. And forgive me for putting them in a table, it's rather crude, but the purpose is just to help a little with comprehension and clarity. So in short, in a media case, the claimant will intend usually to get a permanent prohibition on disclosure at trial if they're successful. For example, because the disclosure would be a breach of confidence or be a libel. Also, that means that the claimant relies on a cause of action on their case at trial, and that cause of action would, if successful or made out, result in a permanent prohibition on disclosure. So that means that on an application in a media case for an Indo, the question is whether, because there will be a delay until the cause of action can be determined at trial, the question will be whether relief should be granted before trial to prevent irremediable harm. This will be familiar to us because this is the operation of the American cyanamide jurisdiction. In other words, should the court grant what the claimant is seeking early, should the court front load the relief sought, because there will be some irremediable harm imposed on the claimant, because if they have to wait until trial to get that relief. I've mentioned American cyanamide, but we'll talk a bit later about how testing the American cyanamide is modified in this context, potentially. And the third row in that table characteristic of the media cases is that the claimant will say that there is no point in the near future where disclosure will cease to be harmful. This information or this proposed disclosure is a libel or it is a breach of confidence. And that will not change in the near future, the claimant will say. And the fourth row there, important element is that the information that the claimant in a media case seeks to withhold or get protected is likely to be information held by someone else. That is something that arises by definition. For example, a news reporter may have got hold of information that you do not want published. And the fifth row follows from that. If there is any urgency in an Indo application in a media case, that will be because of the risk of disclosure by whoever is out there and holds the information. And then I have the second column there, characteristics of our civil fraud cases. And this is something of the flip side. So instead of a permanent prohibition on disclosure, the first row there, the applicant will seek a temporary prohibition on disclosure. And that will end long before any trial, of course, because the trial will have nothing to do with any entitlement to prohibit disclosure. It will have something to do instead with other causes of action, for example, a claim in deceit. And the second row, there is, as a result, no reliance on any cause of action seeking, which results in a permanent prohibition on disclosure. It's unclear, of course, how someone in a civil fraud setup scenario could have such a cause of action, because, of course, only the applicant is privy to the information that they seek to restrain disclosure of. In other words, the fact of the proceedings and the content of the order, because the proceedings are being initiated by them. The need for the prohibition on disclosure only arises because the applicant is going to seek an interim order, and they have to reveal some information which is currently in their pocket if they want to get that interim order. And the third row there is that in the civil fraud context, there is a point in the near future where disclosure of the information will cease to be harmful. In other words, normally, once your wrongdoers have been served with whatever proceedings you're seeking to serve, and the relevant steps have been taken to avoid them trying to defeat your efforts. And that is, of course, the whole point of embarking on this journey, that you can initiate your proceedings against the wrongdoers when you're in a good position to do so, when you have the relevant information and when you've permitted for the preservation of assets. The fourth row there is a corollary of what I've spoken about already. The information that is sensitive in the civil fraud case will be information only held by the applicant. It won't be held by someone out there in the ether, for example, some news reporter. Of course, there may be elements of the information which are out there. There will be information, there will be facts in your application, in your witness statement, which you've derived from other people. But it will likely only be the applicant who has drawn all those together and put a potential case together. And as a result, the fifth row there is that any urgency in a civil fraud case when seeking an Indo will not arise from a risk of disclosure because the information will be in the applicant's pocket. It will instead arise from any need for the principal interim relief to be granted urgently. For example, if we are on a hot pursuit and we want to get our Norwich Pharmacal order quickly, that would give rise potentially to a need to also get the Indo on an urgent basis. And I've put in brackets there the spy catcher principle. This is a principle arising from the media cases. In other words, you may get an Indo against the respondent, for example, newspaper one, but under the spy catcher principle, if another newspaper, other third-party non-parties are given notice of that order, they can be bound by that order not to disclose what is protected by that order. And that's reflected in the penal notice to the model order in the media context, in the Indo guidance that I'll talk about. But it's not usually necessary to rely on this principle in the civil fraud context because, as I've mentioned, the information you're trying to protect will be in your pocket. It will normally not be held by several news reporters out there somewhere. I'll talk about the jurisdiction to grant an Indo and this Indo guidance that I've just mentioned. The jurisdiction to grant an Indo, whether in media cases or in the civil fraud context, arises from the court's inherent jurisdiction. And if any authority were needed for that, that is up on the slide. The jurisdiction to grant an INDO is not a new one. There's plenty of authority on it. Of course, much of it comes from the media cases, and that is something of a difficulty for us. The INDO guidance that is cited there on the slide is something of a starting point for us. It was issued by Lord Neuberger when he was the Master of the Rolls in August 2011. It's issued as guidance, not as a practice direction, and it arose from the Committee on Super Injunctions, which was announced in 2010 by Lord Neuberger. The purpose of it was to examine issues around injunctions being used to bind the press, and the committee was convened at a time of acute public debate, possibly the peak of public debate about that issue in the UK. And the Indo guidance that I have there, what I'll call the Indo guidance, that practice guidance, that contains the guidance and model order which was recommended in the committee's report. And if there were ever a need to delve very deeply into why some element of the practice guidance has been put together, the committee's report is one place to look for that reasoning. So the purpose of that guidance, because of its provenance, is that guidance is primarily directed at the media cases. So actions founded, for example, on grounds of privacy or confidentiality or threatened libel, as I've mentioned. And you can see that being the purpose from the committee's report. One passage in the report says that practice guidance should be issued, setting out the procedure to be followed when applying for interim injunctions, with the aim of protecting information said to be private or confidential pending trial. Such interim injunctions should in future be referred to as interim non-disclosure orders. So the committee did have in mind, of course, the media scenario where you're seeking to front load the relief you're trying to get at trial. There is mention in paragraph 1 of this Indo guidance of a Norwich Pharmacal order, and mention of how an Indo can be obtained in support of a Norwich Pharmacal order, albeit that the Norwich Pharmacal that is described in paragraph 1 is a Norwich Pharmacal in support of a media claim, for example, a claim for breach of confidentiality, or breach of confidence, I should say. But this Indo guidance is nevertheless a starting point for the key principles here, especially the open justice principle that I'll talk about. This Indo guidance is therefore both important and in an awkward posture for us in the civil fraud context. So let's talk about the second stage of this presentation, the legal test for obtaining an Indo in the civil fraud context. So we will come to in a bit what can more straightforwardly be said to be part of the legal test, but we do need to start with one statutory provision, which is Section 12 of the Human Rights Act 1998. The relevance and the human rights element becomes relevant because the court is a public authority, and when determining whether to grant an Indo, it will be determining to what extent it should accede to a proposal to interfere with the convention rights to freedom of expression, as that's Article 10 of the convention. And in the Indo guidance and in the media cases, for example, the Brevin case that I have on the slide, the test for the grant of an Indo is stated not to be the American cyanamide test, but the enhanced merits test laid down in Section 12.3 of the Human Rights Act 1998. So it's said to be not that there is a serious issue to be tried on your cause of action, but something enhanced, and that's set out at Section 12.3, which we should come to now. And for context, I will read through the certain other subsections of Section 12. So Section 12 applies if the court is considering whether to grant any relief which, if granted, might affect the exercise of the Convention right to freedom of expression. The third subsection there is particularly important. No such relief is to be granted so as to restrain publication unless the court is satisfied that the applicant is likely to establish that publication should not be allowed. So here we have an allusion to the media scenario I was talking about earlier, front-loading relief, which you're ultimately seeking at trial. And subsection 4, the court must have particular regard to the importance of the Convention right to freedom of expression, and going to another stage here, where the proceedings relate to material which the respondent claims or which appears to the court to be journalistic, literary or artistic material, or to conduct connected with such material, the court must have regard to other factors as well, for example, publicity, public interest, and any relevant privacy code. This gives rise to a problem because there is a mismatch between Section 12.3 and what I've just said about that being said to be the enhanced merits test that applies to an INDO. There's a mismatch between that on the other hand, and on the other hand, the civil fraud scenario, because as we've talked about already, in a civil fraud scenario, you won't be relying on any cause of action to prohibit disclosure, which you will litigate at trial. You won't be relying on any cause of action which you say gives rise to a permanent right to prohibit disclosure. And there is also a mismatch with other cases outside the civil fraud context. I don't need to get into that now, but that is the one example is put up on the slide there for interest. So at first glance, there is a bit of a difficulty because in the civil fraud context, you might wonder how you can get over this first hurdle if you do not even have a cause of action that you will litigate at trial that would prevent disclosure. But appearances can be deceiving, and we do need to bear in mind the difference between the two scenarios we've talked about. There are some possible solutions. So one possible solution is to take the position that Section 12 doesn't apply at all, because you might say that the relief which you're seeking does not affect the exercise of the Convention right to freedom of expression. In the civil fraud scenario, we're not usually stopping a newspaper from publishing something. Usually we're stopping a commercial entity from informing some other commercial entity of certain information which doesn't have any journalistic quality. But there are some problems with applying this solution of using this proposed get out. The Indo guidance at paragraph 1 is fairly broad. It mentions Norwich Pharmacol, and in the next sentence it states in a quite general term that all such orders, and by orders we mean Indos both for in the media context and Indos for the Norwich Pharmacol, in support of the Norwich Pharmacol, which is described in the Indo guidance. All such orders will seek to restrict the exercise of the Article 10 Convention rights of freedom of expression through prohibiting the disclosure of information. So that's a problem. Another problem is that Section 12.4, which I'll just go back to now, before the and, it talks about the particular regard to importance of the Convention right to freedom of expression. And then after the and, it says where the proceedings relate to material which the respondent claims to have a journalist, literary, etc. quality. That suggests that what Parliament had in mind is that you may have cases where freedom of expression is interfered with, but there isn't this journalistic, literary, or artistic angle giving rise to those extra elements in subsection 4. There's also a problem in that the Convention case law suggests that even expression that I've talked about between commercial entities could be protected by Article 10. There is authority in the Strasbourg case law to the effect that information of a commercial nature, such as advertising, even that is protected, and that private communications can be protected as well, albeit that the case example I have there is not in the context of commercial communication. Further, in the UKIP and Brain case, UKIP argued, I don't need to get entirely into the facts there, but UKIP's counsel attempted a novel and an ambitious argument that the relief that they sought, an Indo, would not, if granted, affect the exercise of the right of freedom of expression, because the defendants denied even having possession of the information, which is to be the subject of the proposed injunction. But the court rejected that argument, and it also said that Section 12.1 speaks of relief which might, if granted, and might is up there on the slide, might affect the right to freedom of expression. So the court takes a, quote, worst case approach. Now, in the worst case scenario, is it still possible that the convention right will be interfered with? So there are some difficulties with saying that an Indo, even in the commercial context, will not affect the exercise of the convention right. So let's go to a potential second solution. And the potential second solution is relying on the House of Lords judgment in Cream Holdings in Banerjee. This is an important judgment in the at least in the media cases, because it's the leading interpretative judgment on Section 12.3. I'll read out what we have on the slide. On its proper construction, the effect of Section 12.3 is that the court is not to make an interim restraint order unless satisfied that the applicant's prospects of success at the trial are sufficiently favourable to justify such an order being made in the particular circumstances. As to what degree of likelihood makes the prospects of success sufficiently favourable, the general approach should be that courts will be exceedingly slow to make interim restraint orders where the applicant has not satisfied the court that he will probably, more likely than not, succeed at trial. In general, that should be the threshold the applicant must cross before the court embarks on its discretion, duly taking into account the relevant jurisprudence on Article 10. But there will be cases where it is necessary for a court to depart from this general approach, and a lesser degree of likelihood will suffice. And the circumstances where this may be so include those mentioned above, and this is above in the judgment, but they're summarised here, where the potential adverse consequences of disclosure are particularly grave, or where a short-lived injunction is needed to enable the court to hear and give proper consideration to an application for interim relief pending the trial or any relevant appeal. So one might say then that Cream Holdings provides for Section 12.3 to have a built-in sliding scale, a built-in flexibility which can be modulated to what sort of application you're making. But there are still a couple of problems with this. The first problem is that Cream Holdings only has in mind that the level of likelihood you need to show might change, might be moved on a spectrum. But it doesn't remove the need to assess the likelihood of succeeding at trial in preventing disclosure. There remains a mismatch. And while there is mention of, quote, short-lived injunction here, what it appears the House of Lords had in mind was a short-lived injunction in order to give additional time before there is a proper hearing about an indo in a media context. In other words, an indo about a cause of action pending trial. Because of the words pending the trial, it seems that the court still had in mind the media context. So a possible third solution is to suggest, or take the position that subsection 3 itself specifically doesn't apply in this context, or at least applies in a different way, because of the wording built into subsection 3, restrain publication before trial and likely to establish that publication should not be allowed. So the suggestion would be that Parliament did not have in mind the civil fraud context when it legislated subsection 3. There are a couple of problems still in that there is a lack of any express carve-out for this in the Indo guidance. This sort of carve-out isn't mentioned. And on a literal, very, very literal reading of Section 12 in its entirety, you might say that there is still a problem and that Section 12.3 still applies. But this is likely to be the most feasible of the solutions. So let's see what the cases have done, and by cases I mean cases in the civil fraud context. And the courts are not as interested as I am in this problem, because they seem to treat Section 12.3 as not applicable at all. In the LMN and Bitfire Holdings case, the claimant sought information orders against cryptocurrency exchanges to assist in their pursuit of stolen crypto assets. The thieves were not known, their identity was not known, and the court made what it called confidentiality orders, which directed the defendants until the hearing or further order, except for the purpose of obtaining legal advice, not to inform persons other than subsidiaries of the proceedings or the contents of the order. So that is the typical wording of a civil fraud indo. It also, just out of interest, it ordered that the defendants contacted their subsidiaries about the claim. It ordered that if the defendants contacted their subsidiaries, they should obtain an undertaking from those subsidiaries not to inform others about the claim in a form which was annexed to the order. But the fifth defendant before the court at the return date submitted that element requiring a subsidiary to grant an undertaking, offer an undertaking, was not acceptable if in a context where the subsidiary would be forced to submit to the jurisdiction of the English court. and that objection did survive. So that's something of a contextual point to bear in mind if you are dealing with a respondent which may have subsidiary entities. But interestingly, in this case, the Indo Guidance, the Human Rights Act, Cream Holdings case, and the Brevins case, none of those were cited. Going then to the Hulley case, an Indo was granted here in support of the Norwich Pharmacol order. That order was sought against solicitors instructed by the Russian Federation. There were no detailed reasons given for granting the Indo, and there's another common theme that the court will often, in the civil fraud scenario, not give a very detailed judgment about the Indo element of the application. It will primarily be concerned with the primary interim relief, for example, the Norwich Pharmacol. So we have some difficulty in identifying how the court is thinking. But the court said that it was mindful of the possibility that if given notice of the application, the solicitors in question would face the question and therefore the uncertainty of whether, as solicitors, they're professionally bound to inform the Russian Federation, and therefore the Indo was valuable. And the Indo Guidance, the Human Rights Act, Cream Holdings, and Brevin, none of those were cited. Going to another case, Renaissance Securities. This is where an Indo was granted, and this was in the context of an anti-suit injunction. The Human Rights Act, Cream Holdings, and Brevin were not cited, although the Indo Guidance was cited. And I won't go into the passage there, just for the purposes of time. But I'll turn to Cancri Investments. That's the last in the series of the cases I'll cite. And here the applicant sought a seal and gag order, so both a gagging order and an order for sealing of the court file. And this was sought not to prevent media publication, of course. This was sought to support an application for third-party disclosure against a bank. This was sought on the basis that the defendant in the proceedings had breached disclosure requirements in a freezing order, and if informed of this application against the bank to get information from the bank, the defendant may dissipate his assets. This is cited earlier in my slides as authority for the proposition that the court uses its inherent jurisdiction to grant an Indo, and the court did grant the seal and gag order for three reasons. First, the legitimate interest of the court in ensuring its orders are effective was strong. In other words, the interest in making sure that the principal interim relief is not undermined by secrecy being compromised. And in this, as part of this first element, the free speech rights in question were not considered to be strong. But it's interesting that the court still considered free speech to be in question here, even though this was commercial private speech in question. The second element was that the seal and gag order would have a limited temporal scope. And the third element, the third reason, was that similarly to the position in the Hulley Enterprises case, the bank would be actually assisted in that it wouldn't have the dilemma about whether it's required to make the disclosure. Its hands would be tied. So your head may be in your hands because I've told you that there is a possible legislative provision that applies, but we don't know how far it applies. It seems on first impressions to apply, but there's a mismatch between that and the present context, and the courts have seemed to have ignored this problem so far. So how do we present the law before the judge on our application? One possibly sensible approach would be to set out the position, set out how the courts have dealt with this, nevertheless set out that there is Section 12.3 and the law on that. But to argue that Section 12.3 doesn't apply or does need to be adapted for the reasons I've given, but to also say that in the alternative, even if the court does want to apply this enhanced test, what this requires the court to do is to consider that there needs to be a very good case for granting an Indo, because the Indo is a special form of interim remedy. It's a form of interim remedy which interferes with Article 10 of the Convention. So that's how you might deal with that first potential element of the legal test, Section 12 of the Human Rights Act. But now we turn to what's more straightforwardly part of the legal test. And this is demonstrating to the court that the open justice principle is being interfered with in a just way, on a just basis. So the open justice principle does apply here, similarly to how it might apply if you're seeking to have the court sit in private. But you can readily see why the open justice principle applies here, because you're trying to block facts about legal proceedings from being disclosed. For example, the fact of the proceedings and the contents of the order. And the Indo guidance is particularly useful here in that it sets out the elements of the open justice principle and how those elements apply. First, the open justice principle is a fundamental principle, and the general rule is that hearings are carried out, judgments and orders are public. That's paragraph 9. Paragraph 10, which is particularly important, and this is where we come closest to what we can say is certainly the legal test. Derogations from the open justice principle can only be justified in exceptional circumstances when strictly necessary as measures to secure the proper administration of justice, and no more than strictly necessary to achieve their purpose. And then turning to paragraph 11, if the relevant requirements are satisfied, the court doesn't just have a discretion to grant an indo, it has an obligation to either grant or refuse. The burden of justifying the indo is on the applicant. It needs to be discharged by clear and cogent evidence. That's paragraph 13. And paragraph 15 talks about the rarity of superinjunctions. So in the media context, a superinjunction is considered to be rare and exceptional. A superinjunction prevents the disclosure of the fact of the proceedings in the order. But of course, in the commercial context, that tends to be precisely what you want to prohibit disclosure of. And there isn't this difficulty of justifying a superinjunction, because one of the elements in the media cases would be that the fact that a newspaper is subject to an indo is not necessarily prejudicial to the applicant, because that newspaper may regularly be subject to such orders. It may just be part of the day-to-day business of that newspaper. But if you're getting an indo against one commercial entity which has never appeared in any court file, then the hairs may be set running. That's the open justice principle, but I would also say that as part of the legal test, one needs to consider convention rights, and we need to buckle up because there's some actual public law we need to consider here. Because the court will be interfering with Article 10 of the Convention, we need to explain why, we need to show to the court why that interference is proportionate. And indeed, some of the facts you seek to disclose might actually fall outside the open justice principle. They might not be facts about legal proceedings. So I've set out the text of the Convention. All I need to talk about for those purposes is that it has a two-stage structure, like generally the qualified rights in the Convention. The first stage is the paragraph of the Convention sets out what the scope of that right is and what amounts to an interference with that right. And then the second element is the reasons why any interference may be justified. If there is no justification, then the interference becomes a violation of the right. If there is a justification, then the interference is an interference, but it's one which is justified and doesn't result in a violation. So the way that the court assesses whether an interference with the convention right is justified is by applying and employing the test of proportionality. And an authoritative statement of that test is set out in the Supreme Court's judgment in Bank Mellat. There are 4 stages. First, whether the objective of the interference here would be the indo, is sufficiently important to justify the limitation of the right. Second, whether it's rationally connected to the objective. Third, whether a less intrusive measure could have been used. And fourth, whether a fair balance has been struck. So here, the arguments that you use in relation to the open justice principle will also apply. But here, the base value that you're interfering with is likely to be less of a hurdle for you than the open justice principle. The open justice principle will almost always have very powerful sway, but the convention right expression is likely in the commercial context, as was said in Cancri, not to be hugely concerning court. We're not stopping a newspaper from publishing something. We're stopping a commercial party from communicating on a private basis. And the other difference from the open justice principle would be that here the structure of your arguments would be a bit different. And usually it's straightforward to show that there is a legitimate aim for obtaining the indo, and that there is a rational connection between getting an indo and your objective, which would be to prevent disclosure of something sensitive. But you can also, your arguments are likely to also include that the injunction is intended to be short-lived, although it may be difficult initially to tell the court when you're going to serve your proceedings on the wrongdoers. That's often a problem here. Your arguments will likely include that there is not a right to journalistic or artistic or socio-political expression being interfered with. And the argument raised in Cancri, you may deploy that here, that the order might actually simplify matters for the respondent and make things easy for them. I should also briefly mention that even in a pure indo, even where you only seek to prevent disclosure, you're not seeking any other element of an injunction, and you will be required to give a cross undertaking damages. And you may well be giving that cross undertaking anyway because of the other relief that you're seeking. Let's turn now to the procedural issues. This is the third and final section. There's a question about whether you get your relief in 2 stages or in 1 stage. So as I mentioned earlier, typically you will, in the civil fraud context, be seeking primary interim relief, such as a Norwich Pharmacol order, but also the indo in order to protect confidentiality while you seek that primary relief. And the question is whether the court should have the first hearing, which will be without notice, typically, and almost invariably in this context, it will be without notice. If it is without notice, should the court grant everything in one go? Should it in 1 stage grant both the indo and the primary interim relief you seek? Often it will be attractive to the court to take a 2-stage process, and that is the norm in certain other jurisdictions, as was mentioned to the court in Cancri. And in Cancri, the court preferred, despite the attempts by the applicant to get a 1-stage process going, the court preferred the 2-stage process. So that 2-stage process would be that at the first stage, you get your indo without notice and any other privacy orders you want, get those without notice. And then at the return date, you come back and you argue about the principal interim relief, for example, the Norwich Pharmacol order, but that is all done under the protection of the indo you got at the first stage. This will often be attractive to the court, and because if the court will often say that if there is no need to depart from this position, it's always better if you can to deal with things on an inter partes basis. The court will also have in mind is that there's a real likelihood in this context, especially if you're dealing with an innocent third party, that if you get your indo, serve it on that innocent third party. You also serve the contents of your full application, which will also set out the principal interim remedy you're seeking at the second stage, for example, your Norwich Pharmacol. There's a real chance that the innocent third party will come to an agreement with you, and the second stage will not need to result in a hearing. This will often be attractive to a court where you're going to the court, you're going to a busy interim list, and the court is struggling with its workload. And it's likely that you will need very good reasons of urgency to convince the court to do everything in 1 stage. You likely need to be able to say that there is this acute pressing need to get both your indo and your Norwich Pharmacol in 1 go. And where you're seeking information as part of your primary interim relief, for example, in Norwich Pharmacol, well, you could attempt to argue that doing everything in 1 stage doesn't matter because the court is only imposing an obligation to give information. It's not freezing any bank accounts, and the respondent, if it wants to, can simply apply to vary or set aside the order. But that is unlikely to. And that argument could be attempted, but there are difficulties with that argument because, of course, you're still imposing on the respondent a mandatory order, and the court will likely be nervous about that. I should mention that the hearing will almost certainly be without notice. That's almost certainly what we want. And I've just pulled together the provisions on without notice applications. In the CPR provisions will likely be familiar, but I should also mention that Section 12.2 of the Human Rights Act states that if the person against the against whom relief is sought is neither present nor represented. No such relief is to be granted unless the court is satisfied there are compelling reasons for going without notice. So this is slightly different wording to the CPR, which uses the wording good reasons. So what you'd likely want to do is show not just good reasons, but compelling reasons, insofar as the semantics matter. And the Indo guidance at paragraph 18 expands on the Human Rights Act element, and it does mention as an example of a compelling reason where the facts of the case are that a respondent or non-party being notified would take steps to defeat the order's purpose. So even though the Indo guidance is about media cases, there is an example there at paragraph 21 of a fact pattern similar to our usual commercial civil fraud setup. And now, because I'm talking about without notice applications, it's an opportunity for me to sermonize about the duty of full and frank disclosure and fair presentation. Of course, this arises on without notice applications by definition, and it's likely to have come across your desk before, obviously. Overall, the headline here is that this is a very important matter. It should have blinking red lights in your plans when you're going down this route, and it's a very large potential pitfall. Overall, in a nutshell, it's helpful to treat this as a duty to fill the gap that exists by the other side not being there at the without notice hearing. So in other words, doing what the other side would have done if it were there to argue its case. And what the rules require are set out, for example, in the Fundo Soberano case that's on the slide there. And I also refer you to paragraph 30 of the Indo guidance. What I should mention is that just the key points from this, although the full guidance needs to be considered, what's required is a full and fair disclosure of all material facts. This includes making proper inquiries before making the application. So the relevant facts don't only include what your client knows, but what your client would know if they had made reasonable inquiries or proper inquiries. And of course, if this duty is breached, at the return date, the court has a discretion, although not an obligation, to discharge your ex parte order, notwithstanding its other merits. So that's just the huge pitfall here. And although the principle is often expressed as a duty of full and frank disclosure, what the court in Fundo Soberano said was that the ultimate touchstone is whether the presentation of the application is fair in all material respects. So the way that you summarize and present the evidence also needs to be, as a whole, not misleading or unfairly one-sided. So it's not just about including everything in the bundle. It's about presenting things fairly. And of course, it's not in the client's interest to overlook this, even though they might be bullish about avoiding disclosing certain matters. In the witness statement, make sure that the relevant points that may be taken against you are made either in line dispersed through the witness statement according to the context or as a separate section, and bring these things out in the witness statement and don't rely on the exhibits and documents buried in the exhibits to make these points. In the skeleton, which will be counsel's job, there will likely be a separate section on full and frank disclosure, and that will cover not only facts to be disclosed, that will not only bring out what's in the witness statement, but also bring out arguments that the respondent might make against the applicant, and as well as application of law to the facts. And often a point that you will want to flag to the court that may be taken against you is that the respondent is an innocent third party. They're not a wrongdoer, so they would have no reason by default to inform the wrongdoers of anything. But this argument, this will turn on any relationship between the innocent third party and the wrongdoer. The wrongdoer may be provided services by or might have a contractual relationship with the innocent third party. And if you're, of course, seeking to take the one-stage route, of course, this duty will apply not only to arguments against an Indo, but arguments against your principal relief sought. It's important to advise the client of this duty as soon as possible in the process. They likely haven't thought about this before. And I've mentioned the need to make proper inquiries. Your client may need to make cross-departmental discovery or inquiries about the relevant information. It may take a great deal of time. And then a mundane matter is to index your exhibits the witness statements, make it clear in the bundle where everything is. These are all points that can help to defend you when and another front is opened against you and attack is made against you at the return date on the basis of this duty. I should just mention that the Indo guidance says that the PD 25A applies. This is mentioned because Indo guidance is from 2011, but this PD has now been deleted with effect from 6 April 2025. You have to look at the White Book 2024 in order to see this PD. And largely, the way that this has been moved around is that paragraph 1 of the PD, which Lord Neuberger refers to, was about allocation to levels of judiciary. That is now in PD 2B with significant changes. And then paragraphs 2 to 5 are largely transposed into the new CPR 25.6, 25.9. I should mention briefly post-hearing matters. There is a practice direction, and this also has provenance from Lord Neuberger, about filling a form, agreeing this form between the legal representatives and sending it to the judge, which sets out the facts of the application so that it can be sent off to a statistician, and statistics can be gathered about the operation of Indos and how Indos are being made. And this requirement, this PD, is often buried and overlooked because it's not mentioned in the Chancery or Commercial Court guides. It is mentioned in the King's Bench Guide, which was very recently updated. There is some uncertainty here about how far the court is concerned with gathering statistics about Indos granted in the civil fraud context because of the wording of the PD, and I won't get into it now. But depending on your risk appetite, it's probably best to do this in order to fulfil your duties to the court, and the court can then take a view about whether it sends off the materials to the statistician. And there's provision will likely be made for the Indo to come to an end. It may be that the Indo can come to an end at the return date, and that is ideal. It may be necessary for the Indo to keep going after the return date and go until you've served the wrongdoers. And there are some difficulties with convincing a court of that course. But if that is the course you've convinced the court to take, of course there'll be a need to very, very quickly after the Indo becomes not necessary to write to the court and the other party to have matters dealt with. And I should make some points about the relevant documents. The witness evidence, of course, there'll be 3 key topics to cover in relation to the Indo in the witness evidence. 1, what information is sensitive. 2, why disclosure would be damaging. And 3rd, why disclosure is likely or at least a possibility. There's a draft order, there's a draft model Indo in the Indo guidance. It's in its model form. It is then slightly adapted in Appendix B of the Chancery Guide, Appendix P of the Chancery Guide, and then thereafter it's likely needs to be heavily amended for our purposes in the civil fraud context. The typical amendments likely to be that at paragraph 6 and 7 of the Indo guidance, that's likely to be replaced with the model wording that I have earlier in the slides from paragraph 26 of the model search and imaging order. But you can also modify that as needed, and there might be elements of paragraph 6 to 7 of the model Indo order in the Indo guidance, which is of relevance. Typically, you would also exclude paragraphs 8 to 9, paragraphs 13, 21, Schedule B, paragraphs 2 and 5, and Schedule C to E, because those are to do with serving non-parties under the spy-catcher principle. Paragraph 15 can normally be excluded because that's about information already in the public domain. And importantly, you need to provide to the court a comparison, something like a track changes version between the model order and the order you're proposing. Of course, mundane point, have that comparison in color, printed out in color, make sure the color looks good on paper and the judge can read it. Sometimes on screen, it looks good, but on paper it doesn't. It may be useful to name in the order specific persons to whom disclosure should not be made as well. As for the hearing notes, there's some practical points to be made there. It's also necessary if you're going without notice for a hearing note to be prepared of the without notice hearing. It needs to be a full and accurate note per paragraph 43 of the Indo guidance. A near verbatim note as a result is useful if possible, including for example, the page references you took the judge to, that your counsel took the judge to. One method of doing this, of course, is to type it out very roughly during the hearing so that everything is there, and then tidying it up into a near verbatim form. State in your hearing note what the limitations of that note are. Get the note settled as soon as possible to avoid criticism that you're relying on a flawed recollection. That can potentially save you later. Agree before the hearing who's going to take the note. Don't assume that junior counsel will take the note, although of course they should have that in mind. And do take a note of the judgment of the court, even if it's a very brief extempore judgment. The judge might comment that they consider that the duty of full and frank disclosure has been complied with, even though the judge may be saying that prematurely, and that wouldn't bind a later judge. There is also the matter of service. I'm going to go a little bit over time. Feel free to disappear if you need to, of course. As for service of the documents after the without notice hearing, that needs to be done as soon as practical under the CPR 25.9. You want to comply with this, but you also want to get the other side's attention, because they might be an innocent third party who will disagree with you once they're served. Serve not only all the application documents, but it's useful to just serve the hearing bundle and the authorities bundle. That will help the other side to understand what's happened. Prepare certificates of service, including from your process servers. Keep a note of all steps taken. Those steps will need to be put into evidence potentially for the return date to avoid criticism. Potentially be strict with your process servers. Understandably, they might omit details which are necessary for you to demonstrate to the court. And if the other side is being difficult, if you're struggling to get their attention, of course, there are ways in which you might try to get their attention in a radical way by posting not only to their registered address, but also to their directors, to their CEO, to the head of their legal department, their head of compliance. Their directors might have addresses associated with other companies on Companies House that you can use. Some Companies House filings for a company might have at the bottom a presenter. So presenter is typically the solicitor who's has made the filing at Companies House on your lay client's, on the third party's behalf, on the respondent's behalf. That might be a way of you contacting a solicitor who is or has been instructed by the respondent and might actually contact the respondent for you. But obviously, you need to be very careful when contacting someone who is outside, who is not the respondent, in order not to reveal anything sensitive. It's likely sensible simply to state that an order has been served on the respondent, and the respondent should contact you, the solicitors, as soon as possible. And I should mention very briefly that, of course, I've only talked about INDOs, but there are 3 other elements of privacy-related relief that you might want to look at, that you'll likely want to seek in this context. One is convincing the court to sit in private. There is provision for this in the model orders, although there may be alternatives. In the Flow Creek case, the court declined to sit in private despite the parties both seeking that. Instead, it ordered that there be no transcript or report of the hearing released without permission, pending hand down of judgment, and it ordered that there be no use made of any document which had been disclosed on the basis that it had been read to or by the court. I've mentioned the sealing and gag orders in the Cancri case. Of course, you may well seek a sealing of the court file. That's very likely. The practical point, do of course check CE file, as sometimes the court overlooks the need to seal the file by a certain time point. And when you do have a hearing, check the cause list as soon as possible, or get your barrister's clerks to do so, because sometimes the court might forget to list the matter anonymously. And you might want to contact the court as soon as possible to get that cause list amended in its name. And the other element of this would be publication of the order and judgment and any anonymity to do with that. Where the court sits in private or orders any anonymity, the basic position is that a copy of the order will be published on the judiciary website unless the court directs otherwise, so that you will likely want to ask the court either not to publish or to consider publishing in a redacted form. And of course, do redact your documents properly. One technical difficulty is sometimes a document may look like it's redacted because the wording has been colored black, but you want to make sure that wording is actually deleted, that data is deleted from the document before it's sent anywhere. That is something of a mundane pitfall. So thank you for your time. Thank you for listening. Apologies for overrunning. Feel free to contact me if you have any questions or thoughts at that address. Please do join us for our next junior program, which will be on the 13th of May, which will be in person, which will be to do with the private client area of practice. And thank you for joining and have a good day.